Welcome to the video. This video is for those who either own property or maybe you know someone who owns property who you're concerned with what will happen to the property after the property owner passes away, especially without a will. So today we're going to discuss the probate process real briefly, but more importantly, how to avoid the probate process altogether. So let's go ahead and get started. My name is Mike Castaigne, and full disclaimer, I am not an attorney, nor am I giving legal advice. However, I am a real estate agent who specializes in probate and trust real estate sales. I've been licensed as a real estate agent for over 20 years and have an expertise specifically with probate and trust transactions. Today, we're going to discuss what probate is real briefly, give you an explanation of that, and then we're going to really dig into how to avoid the probate process altogether, because the probate process can be very time consuming, and there's many legal requirements and timelines to be met, and it can be overwhelming and very stressful, especially when there's a loss of a loved one and you have to dispose of property. And specifically, I'm going to be talking about real estate as it relates to administering the estate of a deceased person. So there's a lot of other things that go on along with probate and the assets involved, but my presentation will be specifically on probate, but you could get an overall view of what happens in the probate process and how to avoid it altogether. So the brief summary, a real succinct and brief definition of probate is a court-sanctioned process that allows the transfer of a deceased person's property to the heirs and beneficiaries. Basically, the probate process involves gathering and valuating all the assets owned by the deceased person, notifying and paying off any creditors that the deceased person left behind, any outstanding bills, as well as liquidating all the assets that belong now to the estate of the decedent and distributing the monetary equivalent or physical assets to the heirs. And there's two types, there's a couple different types of probate processes, and I go further into this in another video that you can access that I'll talk about at the end of this presentation. But there's what's called full authority and limited authority. And full authority is exactly what it says. There's no court supervision. If any sales price of and again, I'm using real estate specifically throughout this presentation. If the seller, the estate, and a buyer agree on a sales price, any agreed upon sale price is okay and does not require court approval. And likewise, any deposit received and agreed upon by the estate is okay, as long as all the heirs and beneficiaries are notified through the appropriate court documentation. Everything is okay to proceed. And the benefit of administering a probate estate with full authority is that the estate and the heirs can proceed to final distribution in a real time efficient manner. And I could get into that a little later. And again, I have more details on that in other videos. Limited authority is when the estate, possibly an example of a limited authority situation is when the decedent dies passes away without a will, and there's court supervision that is required throughout the whole probate process. There's a court appointed referee who appraises the estate. And the reason why I have a appraised value in parentheses, because this is not a licensed appraiser. This is actually a a CPA, an accountant who is appointed by the court to appraise the property. And typically this involves some computer research and just a drive-by of the property. There is no physical inspection of the actual property itself, interior, exterior, other than just a driving by the property. So the appraised value can or may not be accurate, but nevertheless, whatever that appraised value is, the sale must be within 90% or more of that appraised value. And if it's not an accurate appraised value, then the estate may be losing, not gaining as much net proceeds as they would if it was undervalued by that that court-appointed referee, or if it's over appraised or overvalued, then you're limiting your buyer pool because you're decreasing the amount of potential buyers who would be able to actually purchase that property. Likewise, there's a court-mandated 10% deposit required on a court-supervised limited authority probate real estate transaction, and that really limits a lot of buyers in regards to the amount of the deposit, not to mention the down payment that can be applied to the property. But a 10% deposit, especially where I practice real estate in California, where the average sales price of a property throughout the state is around $800,000, but specifically in your metropolitan areas like the San Francisco Bay Area or Los Angeles, where prices are higher, like more like on average $1 million to $1.5 million, 10% of that is pretty significant to come up with just the deposit. And then the other things that limited authority requires is a court overbid process, and every time there's an action taken to liquidate the asset, it requires a court hearing. So all these things together just extend the overall timeline of the probate process. And a property or probate sale, real estate sales transaction under full authority can take as little as 3 to 4 months, whereas it might take in a limited authority situation, it could take anywhere from 7 to 9, maybe even up to 12 or more months to liquidate the actual real estate of the estate. But let's talk about ways to avoid probate. And one way to avoid probate is by having before the deceased pass away, the owner of the property enters into or establishes a living trust. And a living trust is a legal document, and it's a legal entity. You could think of it almost as a corporation. It's a legal entity where the owner actually transfers ownership of the real estate to the trust. So the individual owner does not necessarily own the property as an individual, but owns the property. The trust owns the property, where the owner of the real estate is the trustee of the trust. And everything is, while that person is alive, everything can proceed as normal. You would just do your transactions and operate the property as if you were a officer of the trustee of the trust. And then when the owner of the real estate passes away and becomes deceased, the successor trustee, the person who the owner indicated would take over after the person passed away, is now called the successor trustee. That person can now legally act on behalf of the deceased, and is now the new trustee of the trust, and can sign any documents. In the case of real estate, now that successor trustee can sign a listing agreement to put the house up for sale with a real estate agent and place the house on the multiple listing service and advertise to the masses that this house is now for sale, for example. And then when it comes time to transfer ownership of the house and receive uh, money in exchange for the grant deed, the successor trustee can now sign the grant deed and transfer ownership of the property in exchange for the agreed upon sales price. So there's a few ways to hold title. And this is something to think about. And again, I'm not an attorney. This is something that you want to talk with about when you purchase your house, or you can make changes anytime during the ownership period of your property. But there's different ways to hold title. You could talk to this. It's best to talk to a team of people, being your real estate agent. It could include your title officer at the title company, as well as your estate attorney. Can give you guidance on how to hold title, and it's really dependent on your individual situation. So it's good to receive feedback based on specifics to your individual situation. But joint tenancy is when more than one person is owners of the property. And I'm just going to use in this example a husband and wife. It could be two people that are not related who own the property. It could be brother and sister. It could be two friends or business partners. But in this situation, we're going to use the husband and wife. And probate is only required if all the joint tenants have passed away. And I'll give you an example. So let's say there's a husband and wife who are joint tenants, and the husband passes away. Upon the husband's death, probate is not required. All that's required to avoid probate is an affidavit of death certificate of the husband to be filed with the county recorder. And then the wife would take full ownership of the property. And then later, when the wife passes away, then probate would be required. So that's joint tenancy. That's one way to hold title. Another way to hold title is called community property. And in states like California, it is assumed that if property is purchased during marriage, it is considered community property, despite the way you hold title. However, community property is when title passes to the estate, and I crossed out on purpose the surviving spouse. You would think that in community property, when one of the joint tenants or one of the owners passes away, that it would the ownership would go to the other owner or owners. However, title is actually in community property is actually passed to the estate, unless in this case, in this example, we're going to use the husband and wife again, unless the deceased spouse left a will. Now, here's the caveat regarding community property. Theoretically, a husband and wife each own 50% of the property, and the deceased spouse could actually leave their 50% to somebody other than the surviving spouse, such as another individual or a charity. And when that spouse passes away, then the surviving spouse would own 50%, and the person or entity that the deceased spouse willed that to would own the other 50% of the estate. And the biggest takeaway on this, if you hold title in community property without the proper estate planning, if the surviving spouse wanted to sell the property at the time of death of the deceased spouse or shortly thereafter, they're going to have to gain agreement and from the heirs and other heirs and beneficiaries of the estate, and have them sign off their rights through the title process. to avoid probate, or the surviving spouse or the surviving owner will have to petition the court to transfer full title to them. Again, another thing to talk to more specifically with your estate attorney. Um, Another way to hold title is community property with right of survivorship. And this is also known as the I love you way of holding title. This is actually how I personally hold title. I also have a living trust. My wife and I have a living trust, but we hold title to the property, community property with right of survivorship. And this gives us the same features and benefits as the community property scenario I just mentioned. However, the decedent's 50% under this holding title under CP with right of survivorship, the it's automatically transferred to the surviving spouse, and the surviving spouse doesn't have to do anything. It's just already pre-written in that statute that the surviving spouse now, instead of owning 50% of the property, the surviving spouse or the surviving owner, whatever the case may be, now owns 100%. All those that share or that percentage of the decedent's ownership is now transferred to the remaining owners. And if then later, if the surviving spouse in this example dies, especially without a will, then that's when probate will be required. So there's some other legal methods in terms of transfers and petitions to avoid probate. And the first one I'll talk about is called a revocable transfer on death deed. And this, first of all, can only be used for a residence. It can't be used for an investment property, but it can be used for a residence. And this is a pre-filled out document prior to the owner's death, where the owner is going to transfer property to a beneficiary upon their death. And again, this is recorded with the county where the property is located prior to the owner's death. And then after the death, the beneficiary records the death certificate and files a change of ownership with the county, where title will be transferred to the beneficiary. The next type of petition we'll talk about to avoid probate is called a spousal petition. This is where the property was held as community property, or the deceased willed their 50% to the surviving spouse. And again, community property, the property needs to be acquired during marriage. And this legal maneuver is usually used when the surviving spouse wants to sell at the time of the deceased spouse's death or shortly thereafter. And this goes through the court and the semi-probate process, where this will take about 3 to 4 months and requires court approval, because there was a petition and it's submitted to a judge and it's heard in probate court. But it shortens the time that property can be transferred fully to the surviving spouse. And again, it take 3 to 4 months instead of like I said, up to the extended time frame of 7, 9, maybe even 12 or more months in a typical probate case. And lastly, what I'll talk about is a Hegstad position. And a Hegstad position is Hegstad was a legal case that was in a similar situation. And this is when there's a living trust that I talked about earlier, when the property was held in a living trust. But a lot of times when a property is initially financed, when you purchase a property, you have to purchase the property in the individual owner or owners' names. And when you refinance the property, let's say you purchase the property in the individual's owner's names, and then later you transfer that ownership of that property to your living trust. And then maybe years later, when interest rates got more favorable, you wanted to refinance, then you talk to your lender, and the lender says you have to take ownership out of the living trust and back into your individual names, because the lenders have some lenders have requirements that they can only they have to qualify an individual financially versus a living trust. So let's say that property was then the ownership was transferred out of the living trust back into the individual owners names, and then the refinance was conducted, but then the owner or owners forgot to transfer the ownership back into the living trust, and then the owner or owners passed away without the living trust actually owning the real estate. This is when the Hegstad position comes into effect. It's not always guaranteed. There's certain circumstances that have to be met, and again, this takes some court approval. There's court hearings that need to be conducted, and the heirs of the estate need to be notified of this. But there's a petition before the court, similar to the spousal petition, but there's court hearings that can be conducted to attempt to approve the estate to transfer the property back into the living trust. So then all the legal authority can be transferred back to the successor trustee to do what they will as per the guidelines of the trust, as well as the direction of the will, if there's any will, to either liquidate or hold on to the property in question. So that's just a quick overview. And again, it was very high level overview. If you have specific questions about the legal requirements, I suggest talking to a real estate attorney, or excuse me, an estate attorney as well as a real estate attorney. But if you are facing a situation where you are either currently in probate, or you're looking like you're going to have a probate situation, or you just want to pre-plan to avoid probate altogether, or how to navigate the probate process, you could go ahead and text the word resource to 510-369-5080, and that will provide you free access with no obligation to a real estate guide. It's basically a web page that I developed with a lot of probate resources. There's some videos, there's some pertinent documents, there's a special report. There's a couple special reports on there. There's a ebook you could download on the probate process. It's just full of information to educate yourself so you can navigate all the complexities and learn a little bit more about the probate process, whether that's something you want to navigate yourself or with an estate attorney, or you want to not deal with that and try to utilize one of the methods I talked about in this presentation. If you have any specific questions, or you want to have a free, no obligation consultation with me and my team, there's some contact information there by phone, my website. You could go there. There's some additional information. I have a scheduling link on my website. You could schedule a phone call or a video conference with me. Definitely try to email me if you need to. That's a good way to contact me. Or I'm on a lot of social media platforms, and you could contact me there at any time. So I hope this presentation was helpful. If you have any questions, reach out. And again, don't hesitate to contact me. I'm here to help. And I just want to be a resource, because I know how difficult firsthand how difficult it can be, not only to administer an estate when a loved one passes away, but when there's assets to be liquidated, and you're trying to do the best job as a successor trustee in a trust situation, or an executor or administrator in a probate situation. You're trying to do the best job for the heirs and the beneficiaries. I'm here to give any advice I can based on my knowledge and experience as it relates to the disposition of real estate throughout the probate process or the trust process. So again, thank you. And I look forward to talking to you if the need presents itself. Have a great day.